Hi, I'm Rich Bucuri from Pointer and Bucuri, and today I want to talk about a situation where I see all the time. An accident is clearly not somebody's fault, but the insurance company is giving that person 10 or 20%. So if you're in a jurisdiction like Indiana, which is a comparative fault state, the reason why it's important what percentage each party is at fault is that the defendant is able to discount what they may be able to have to pay in damages by the percentage of fault of the plaintiff. So, for instance, if a accident is 100% the defendant's fault, they have to pay 100% of the damages. If they're only 80% at fault, then they can discount the damages that they pay to the plaintiff by 20%. And so, who decides this? Well, ultimately a jury does, but in negotiations, each party can argue whatever they want, and it's beneficial for the insurance companies to argue that a certain percentage of fault is the plaintiff's at the time of negotiations, because then basically they can discount what they say is a fair offer. And there are insurance companies that, as a matter of course, as a matter of policy, will always try to put fault on the insurance companies. And so what you do is they will say, hey, I know that our client ran the stop sign, but we still think that you were 20% at fault because you should have seen that he was running the stop sign and slowed down to avoid the accident. And of course, that's a ridiculous argument, and one that would have a very difficult time winning in court. But what they do is they use that argument to delay and to put economic pressure on you. You're without your car, and if you run it through your insurance, then you got to pay a deductible, and you don't get your deductible back right away. And so they're just hoping that you'll say, okay, forget it, just give me what I can get, and then I'll be done with it. And what I would encourage you to do is to be as patient with the process as you possibly can, and it's always better to have some leverage on your side in the form of an injury attorney that has experience in dealing with these insurance companies and knows how to combat them by, first of all, not accepting a diminished value on your case because of comparative fault when it doesn't exist, and also two, asking for the proper amount of damages as it relates to whatever your injuries were or whatever your other damages were. If you have any questions about your case or how to deal with insurance companies that are trying to blame you for an accident that's clearly not your fault, call Pointer Bucuri Accident Recovery Attorneys.